on the legal's perspective on data security for 2016. And for those of you that might have come from the previous session, we've got some extra law for you. We've got some new things to share. And what more could you ask for?
Back-to-back legal presentations on our
yes,
security summit.
Most of you don't realize this is actually a legal summit with some additional conferences on cybersecurity. So we'd like to thank you for coming back. And my name is Dino Tsibouris, and I'm one of the principals for the firm of Tsibouris & Associates. And I'm presenting today with Mehmet Munur, who's a partner at my firm. A little background about myself. I'm a Columbus native, and I've lived here most of my life. Went to Capital University for law school, spent some time at Bank One Corporation, which is now J.P. Morgan Chase, working with Jamie Dimon's team on information security many years ago, and started a firm in cybersecurity and information security, as well as electronic financial services now about 12 years ago. And Mehmet, share a little bit about yourself.
Yeah, and I've been working with Dino for the last 8 years or so, and a background in technology as well. And I've also worked for a couple of years at IBM before coming back to work with Dino again as outside legal counsel.
And of course, the reason we've been doing this for the last 6 years is the strength of our Dilbert cartoons, because without Dilbert cartoons, all we'd have to talk about is law.
Yeah, and I want to say I'm hoping we were able to Uberize the presentation, and if we didn't sync it with the wireless mesh and the IoT and everything else, it's just going to fall on its face. Let's hope it doesn't. Because is this going on Periscope or Meerkat? No, just on YouTube. All right.
Okay. Maybe we should turn the lights on so you actually can see us, because I feel like we're somewhat in the witness protection program with our faces muffled. So,
can you hear me okay?
So today we're going to be briefly looking back at 2015. We've been doing this for about 6 years. I want to say I think it's important to take a step back and talk about the previous year, simply because we're in the beginning of the year, and then the entire year goes by, and you got to look back and look ahead. So that's what we're going to do. We're going to talk about the federal regulators, how they become more capable and technical. By the time you're done with this, you will see that the federal regulators and state regulators are looking at these issues at a very technical level because they have technologists in their staff. And then we're going to be talking about expanding federal regulation and regulators. We'll look at state guidelines briefly. Some of the most common questions that we get about data security from a legal perspective is, what am I required to do? What's reasonable under circumstances? And one of the state regulators has actually said something about this, so I think it's worthwhile discussing it. And then we'll talk about how to prepare based on some of this information. We talk about then international privacy issues. Some of these issues have been discussed in their previous presentation, so we may not get into it in too much detail if time doesn't allow for it. Having said that, let's go back to 2015. One of the bigger breaches in 2015 was the Anthem breach. It affected millions of people, healthcare data, social security numbers. Office of Personnel Management was also big. The commonality between these two, I want to say, was the action of state actors, or foreign actors for that matter. Both of these breaches were somehow tied to Deep Panda out of China, from my understanding. And any of the other breaches that came up was Ashley Madison. One of the reasons I selected this was because, we think about, private or sensitive data. Europeans have a different understanding of sensitive data. It relates to sexual preferences, etc., that we don't really think about. I mean, we think about it as sensitively, but when we think about sensitive personal data in the United States, you're thinking about credit card data, social security numbers, etc. But Ashley Madison, what ended up happening is the data that they ended up losing was mainly usernames, email addresses, and other preferences that were included there. But it affected individuals so greatly, I want to say something like 2 suicides were tied to this. So don't ever say, hey, a data breach didn't kill anybody. The other issue that keeps on coming up every year after year is this Wyndham case. The Wyndham breach dates back to 2012. So that's when the breach happened. That's when the FTC started going after Wyndham. But unlike most companies that the FTC goes after when they have a breach or when they're lacking in some sort of privacy or security, Wyndham decided not to settle, and they decided to litigate. And the FTC issued an injunction at that point. They tried to obtain an injunction, and the case was litigated all the way up to the appeals court. And I would say most of the legal commentators, we were thinking definitely that the FTC was going to win, that the chances were slim that Wyndham was in fact going to win and be able to argue that the FTC hadn't followed through on its duties to somehow come up with regulation or more concrete guidelines about what it has to tell companies that it can do before it brings an enforcement action. That was Wyndham's argument. You don't have regulations to come after me. And so you have to go back, issue regulations. That's what every single other regulator does. And then you can come after me for having violated them. whereas the FTC mainly relies on its jurisdiction under Section 5 of the FTC Act relating to deceptive and unfair trade practices.
And I think that's one of the biggest distinctions between our presentation and the presentation before us, where they focus predominantly on statutes that govern data protection and data security. What we want to spend some time doing today is going through individual settlements of enforcement actions and litigation so you can see what's actually happening in the trenches and what people are being forced to accept that isn't necessarily in the statute itself.
Right. And one other commonality that you may see among breaches in 2015, and you'll likely continue to see for large breaches going forward, is the effect it has on the C-suite. The CEO of Target resigned, CIO of Target resigned, the director of OPM resigned, the CIO of OPM resigned, and Ashley Madison, CEO, resigned, mainly because of the breaches that they were subject to last year. So I think we'll continue to see some effects of that. Having said that, let's move on to expanding enforcement by other regulators.
Normally when I'm doing presentations, or when Mehmet's doing presentations, we look at the lead federal regulators in data protection, which are primarily the Office of Civil Rights for HIPAA and banking regulators. Those are very common sources of enforcement agencies that use very broad, amorphous enforcement statutes to get very specific results based on failure to follow reasonable security procedures, either in a defined security rule or a particular regulation that turns to a standard, like a NIST standard or something like that. Well, now there's new parties at the table that are expanding their privacy enforcement as well, such as the FCC recently entered into a multi-million-dollar settlement for Verizon for marketing without consumer consent. And the Securities and Exchange Commission brought an action against Artisys, which is a brokerage. It's a broker-dealer. And it's very interesting because the SEC enforcement action focused on the fact that during an audit that RT Jones, which is the legal name of that company, maintained client PII on its third-party hosted web server but did not adopt written policies and procedures reasonably designed to safeguard its clients' information as required by the safeguards rule. So, for example, the policies and procedures for this broker-dealer did not include conducting periodic risk assessments, did not include employing a firewall to protect web servers, did not include encrypting client information stored in that server, or establishing procedures in advance for responding to cybersecurity incidents. And I think it's interesting here because it entered into a $75,000 civil money penalty, and there wasn't an actual breach and there wasn't an allegation of harm. It's a failure to have proper procedures in place. So each of these regulators for organizations in their specific regulatory jurisdiction are now looking at both privacy and data security on a regular basis.
Go ahead. Right, I was actually going to mention that. That's one of the things that the FTC, we're not going to talk about in too much detail, but before the FTC goes about having some sort of enforcement in some area, or before it goes to Congress and say, hey, we need new legislative powers, they usually like to do some sort of study. They did that with big data. They did that with data aggregators. And now they just announced that they're doing with PCI, simply because, as you will know, every single data breach that relates to credit cards come up. Every single one of those entities at the time that breaches happen has been PCI compliant. So we'll probably see more about that in the coming years.
Just for the fun of this, the legal standard for Rule 30A of Reg SP, which is the broker-dealer privacy rule, it's a willful violation if the person charged with the duty knows what he is doing. It's not a requirement that the person be aware he's actually violating the law. So because there are specific data protection requirements for broker-dealers, just the fact that you're working in that area but are unaware of your requirements doesn't protect you.
It goes back to the saying of ignorance of the law.
Yeah,
is not.
see that hand. Yes. Mm-hmm. I think you'll see that because we're going to talk about the Consumer Financial Protection Bureau doing basically the same thing with Dwolla. We're going to look at the Dwolla case, which is a payments processor, and their fine was $100,000. And I think these are meaningful things where they're actually. See, the thing is, these are regulatory actions that arise out of audits, where they find during the audit that there is insufficient data protection, and they they have a breach of their legal duty to protect data before there's an incident. So it's an awareness that there's a problem prior to an incident, as opposed to some of the larger settlements like the Wyndham cases or situations where there's large data breaches that result in mass data theft or credit card usage and things like that. These are pre-harm enforcement actions.
And the chances are that fine is limited so that the regulator can recoup some of the costs that is expended in bringing that action. Basically, I think is what we're trying to get to.
Yeah.
CIAs?
Well, there's settlement agreements that they have to actually, as part of the settlement, they have to agree to ongoing maintenance and ongoing third-party audits and instruction and training and third-party penetration testing.
Right, and basically consent order or consent decree is basically what the particular regulator might end up calling it. And in the FTC's case, in an enforcement action, this is your average enforcement action. What you end up seeing is the entity that is subject to FTC enforcement action has to designate somebody that is responsible for privacy security, chief information security officer, chief privacy officer, but usually both. And then you have to conduct risk assessments. Depending on your industry, you may already have an obligation to do this. You have to test and monitor the risks identified. You have to implement, maintain procedures. And one of the, I want to say, toughest things about an FTC enforcement action is the fact that it lasts for 20 years. And so far, since about 2002, about 50 companies, if not more than 50 companies have been subjected to it. It's the who's who of tech giants. Microsoft, Facebook, Google twice. And we're talking about fines. The first time Google had an enforcement action, didn't get a fine. Second time around, it was for violating Safari cookies on Safari browsers, if you will, and they got a $25 million fine. If you think about it, $25 million fine for just cookie violations seems rather broad, but that was their second time around. They had to have all of those already, and they ended up violating. So that should have been a bigger call to action, but when you think about Google being the second largest company, second most valuable company out there with hundreds of billions of dollars market capitalization, $25 million drop in the bucket. It's probably not going to affect.
And tracking cookies are a major revenue generator for them, so that hits them on how they make revenue by tracking people across networks. Going back to your question briefly, in addition to money, they always include remedial efforts. So in the RT Jones case, they had to appoint an information security manager. They had to adopt written security policies. They no longer store information on its web server, and any PII stored on the network must be encrypted. The firm has to have new firewalls and logging systems, specifically designed to detect malicious incursions.
Right.
Which, as we know, in Target can be ignored and overwritten, but at least you have to have them in the start place. At the start.
And with that, let's talk a little bit more detail about what has happened recently from an FTC enforcement action relates to ASUS, not ASUS like Dr. Seuss apparently. It's ASUS like Pegasus. That's apparently where the name of the company comes. So if you think, well, how do I pronounce this thing? That's how. All right. ASUS is the fourth largest PC maker in the world. You may have seen their PCs, but this enforcement action doesn't relate to their PCs. It relates to their wireless routers. And ASUS started publicizing their routers using phrases such as your secure space, private selective file sharing. These are the new features of the router that they were trying to push. And then increased privacy and the most secure cloud platform. The question is, let's stop right there. Why would you say any of this with any product you're selling? It really doesn't matter because the chances are it's not true. And if it's not true, then you're in trouble because you're going to have FTC looking over your shoulder. Well, the argument against saying these things increases when you have authentication bypass vulnerabilities in your routers, password disclosure vulnerabilities, cross-site request forgery vulnerabilities, and when you create an FTP server, which is one of the main features of this, and you enable it, everybody on the internet can access it. We'll talk about privacy by design and security by design. This is the FTC stepping in saying, you kind of did this wrong. When you enable an FTP server, this is not the way it's supposed to happen. And one of the worst things about this is that it took them about 8 months to remedy this, to issue a new firmware and then email it out to everybody. And in the meantime, individuals' routers were being hacked into, and there was nothing they can do aside from unplugging it because you could have the most secure password if there is, if we're looking at these kind of vulnerabilities, you're simply not going to be able to secure yourself. So as a result of that, the FTC specifically went in. When we talked about risk assessment, and laid out these conditions. ACES, when you are doing a risk assessment in the future, you are going to make sure that you do pen testing. This is the FTC coming out and saying this is probably the third time the FTC has done this from an IoT perspective, but they're specifically calling out security by design. Dino and I are kind of like car guys. We talk about them all the time, and most people drive cars. The equivalent of when you start your car, the transmission must either be on manual with your foot on the clutch, or it must be on park or neutral. Otherwise, the car will not start. If you start the car, you hit something when it's on drive. What they've done, basically, is in effect starting the car on drive, on reverse. So the FTC wants to make sure that all of these areas are addressed. They do penetration testing, and the FTC moves from not just regulating the information that the company regulates to the device. And, words like cloud come to mean so many more things, and Internet of Things, I guess, is becoming more and more. You'll see this enforcement action mentioned with Internet of Things. It's really router. It's not really Internet of Things. It's the watch that's the Internet of Things. But anyway, so you see the FTC becoming more and more technical in this area because they employ technologists who go and research these areas. And that, as a result, end up becoming significant for us because if you're in the business of serving consumers and if you're developing new applications, then you need to be aware of these. And if you don't and you run into trouble, then the FTC will make sure that through an enforcement action that you become subject to them. The next issue I want to move into is Dwolla, talking about startups with weird names. That's apparently web and dollar. So you're sending dollars over the web. The name of the startup is Dwolla. They've been around. It's about 2009. You may have heard about them in talking about Bitcoin. They were one of the early adopters, but then they kind of came and bit them in the end too because Mt. Gox, which kind of crumbled, and DEA agents and everybody else got involved. Some of the money that they were holding belonged to Mt. Gox, so that money ended up being held by them. The reason they got into trouble with the CFPB was very similar to why ACES ended up getting into trouble with the FTC. They made statements such as exceed industry standards. I don't need to go much further, but let's stop right there for a second. What is the industry standard? What industry are you in? Are you a bank? Or you a startup? What is that standard? How do you go about exceeding it? Let's assume you did. Why would you go about saying that, given that, once again, there are regulators out there who want to come after you?
Normally it's deemed as under Grant-Leach-Bliley, reasonable with respect to the complexity and size of the institution. Where's that benchmark? How do you get greater than that or less than that? When you think about that, and the other thing we want you to notice as we look at different claims and different enforcement actions by different regulators, you'll see some common themes and some common patterns, such as representations that would lead people to think something is safe when it's not.
Right. And the other thing is, let's assume you understand what the industry standard is and you don't have to go get 5 technical experts to talk about what that is. You decide what that is on a given day. What happens to it 2 months from now? Same issue that we talk about with PCI. You're compliant with PCI one day. What happens 10 days from now that you're not being tested on? So Dwolla continues to make similar statements online about its security. The trouble is that none of these statements are true. And CFPB comes after them and claims that they made these claims falsely, that they did not in fact employ reasonable, appropriate measures, and that these were misrepresentations. I think it's worthwhile talking about briefly in a little bit more detail what it is that they failed to do. So they were founded in 2009. They made these statements from 2010 to 2014, and then they did not have their first mandatory employee training until 2014. That's a 5-year-old company. That's the first time they're doing risk assessment, first time they're doing employee training. I would like to argue that you need to be doing that from day one, given being a startup is tough, but if you're a startup in the financial services community where you're using a bank and you're a bank's agent, then your obligations are a lot higher. Then you need to ensure that your information security is better. And they didn't do that here. They did some penetration testing where they sent out phishing emails. 62% of the employees clicked the email that was sent. 25% of the employees that clicked tried to create an account in this fake website that was sent. Here's the best part. They did nothing about that risk assessment. What's the point of doing a risk assessment when you're uncovered the kind of facts that they've uncovered and doing nothing about them? And I think what I end up seeing in the fact pattern related to Dwolla is that we have a company that's trying to do things, but it's a little too late and they're not trying hard enough. And the other issue that they run into is that they segregate the data that they have. They have Dwolla.com, where the payments go through. And then they have DwollaLabs.com, where some of the applications, et cetera, the API relating to this platform that they're creating resides. And they have their information security policies, procedures. They're not reasonable, appropriate, but they apply to Dwolla.com, but not to DwollaLabs.com. And the CFPB points at it, it's saying, well, you have information that needs to be reasonably secured on both sides, and you completely ignore that. And think about it in terms of silos. You'd like to be able to do that to a certain extent when you're dealing with PCI DSS. Hey, I've got payment data just in this network, nowhere else. And to the extent that's factually true, fine, limited there. But in the sense that they had just randomly divided up the company and decided to apply some policies in one place, some policies in another, that was wrongful, and the CFPB was not entirely happy with that. And in addition, they transmitted sensitive personal data without any encryption. They emailed it back and forth. You can imagine them being a payments company. They had all sorts of financial information, PIN information, etc. So the enforcement action was very similar to what you see with the FTC. And the reason is because the CFPB has been around for a short period of time. And some of its authority is very similar to the FTC's. Deceptive and unfair trade practices are common between the FTC and the CFPB. The CFPB also has what's called abusive trade practices that's brand new, that they're probably going to expand a little bit more on in the next coming years. But what you end up seeing is that they have to stop these misrepresentations. They have to train employees, and they have to pay a $100,000 penalty. Not much, but then again, we're talking about a startup that processes about $5 million a day, which is nothing, absolutely, compared to the $365 million that PayPal processes. So the other issue that I want to talk about with respect to Dwolla, and probably one of the more important one, is that there was not a single data breach that we know. Nobody's information got somehow hacked. Hundreds of thousands of employees, users' data wasn't out there. So this is the CFPB stepping forward and saying this is their first cyber security privacy enforcement action, stepping forward and saying, unlike the FTC, if you have a violation of the law, which we believe this is, we will come after you, even if there isn't a breach, and you will also pay us, at least, for a minimal amount of $100,000. The FTC, first time around, you may get a slap on the hand, 20-year enforcement action. It's different. But this is the two enforcement agencies taking two different approaches. The next issue I want to talk about, well, for those of us who are governed by HIPAA, that's where you end up seeing a lot bigger fines. This Feinstein Institute is a rather large healthcare group, and they have 21 hospitals and 450 patient facilities. So you can think about that. That's pretty large, a healthcare system. And what they ended up doing is they had a breach, and they ended up filing with the OCR. When you have more than 500 individuals who have been impacted by a data breach under HIPAA High-Tech, you have an obligation to file immediately, assuming there's no law enforcement delay, etc., with the HHS, the Health and Human Services. And the HHS decided to do an audit of them once they found out that they had lost the laptop. And the laptop contained information for 13,000 patients. It included everything from birth dates to addresses, social security numbers, diagnoses, laboratory results, medications, anything you can imagine coming from a hospital. And the HHS ended up finding out that Feinstein's security management was limited in scope, similar to what we saw with Dwolla. That was incomplete, insufficient. They failed to implement appropriate safeguards, and they lacked policies and procedures to govern the receipt and removal of laptops. I think what we're seeing based on our language from the HHS is this person probably wasn't supposed to have that laptop, or that laptop wasn't supposed to have that data. Even if they had that, maybe they should have encrypted it, right, so that this breach wouldn't have happened. The facts of the second case are similar, smaller, and that may be one reason why the fine is smaller. The North Memorial Hospital is out of Twin Cities, Minnesota, and they have a breach similar to Feinstein, and the HHS decides to do an audit of them after the breach is reported. And what they find out is that the business associate they have been employing is the entity that lost the laptop, but they never had a business associate agreement with them. So that's an obligation that you have. You have to have a business associate agreement with every single business associate that you have that talks about appropriate security. And they didn't have it here. They gave the information to the business associate who lost it. The lost data was, and I'm going to say only, relating to 10,000 people. As it turns out, this business associate had access to the information relating to 290,000. So this wasn't just, oh, we forgot. It was just minimal. Now, you're given access to 300,000 information relating to 300,000 individuals. You have to make sure that you have a business associate agreement with that entity.
Yeah.
I believe these are all fairly new. Right. So these are the breaches happened in 2012. So there is a lead time. You report a breach, the HHS takes the time to investigate all of that. By the time an enforcement action comes around, it's quite a few years later.
I think one of the things that we really struggle with in our practice is the fact that I think some people have a degree of compliance fatigue. There's so much that needs to be done. Everybody has limited budgets, and the smaller you are as an organization, the bigger a struggle you have to fight marketing dollars, to convert marketing dollars into compliance dollars. And so as the cost of compliance goes up, what's your return on investment for those compliance dollars? One of the challenges that we're seeing here is that compliance risk isn't some future event. Now what you're dealing with are state and federal regulators that are deeming you out of compliance and penalty worthy before anything bad happens, simply by virtue of an audit or a minor breach identifying a bigger problem. And so a lot of these things, when you look at the underlying fact patterns, and if you just love paper, I have a copy of each of these settlements so you can identify what the alleged failure was and what the remedy is. These are things that you look at them, and I think if you're in the business, would say, yeah, something should have been done about that. So it's easy to look at these settlements and say, well, that's obvious. If they had penetration testing or didn't, and they weren't doing it regularly, and they weren't implementing the changes that needed to be made, or they weren't training, well, what happens is those people probably had about 500 things to do, and that wasn't the only thing that they were dealing with. The point is you really can't blink on some of these things. So you do have to at least make it a point to cover your basics. Make it a point to realize that you don't need to wait until you have a breach before you have an enforcement action and penalties. That by simply failing to have adequate information security and adequate training given the size and complexity of your institution is a violation of law in and of itself.
Right. And I think we see the regulators once again ramping up enforcement, ramping up fines in this area, where you may have gotten away with a slap in the hand a couple of 5 years ago. Now you're not going to. Now it's violation of law. We've told you this before. Here you are. Another example. You're going to end up with a fine. Next issue I want to highlight comes from the California Attorney General Kamala Harris, who's been active in the private security area for some time. California was the first state to pass the first state breach notification law back in 2003, if I'm not mistaken. And she hasn't been around since that time, but one of the things she did was to put together a breach report. Many of these I'm sure you've seen with some of the security vendors that are out there. Verizon puts one out that's very informative. Well, this is from a state regulator's perspective, because when you have a data breach, you have an obligation usually to notify the regulator. That's the case with HHS, as we saw. That's also the case with California and most of the other states. The attorney generals would like to know when you've lost somebody's data so that they can keep track of these things or bring an enforcement action against you if they feel like it. But one of the interesting things that they ended up doing in this case was they said, well, we have an obligation under California law to implement reasonable security. What is reasonable security? So they turned to what used to be known as the SANS 20, and now it's called the Center for Internet Security's Critical Security Controls. And they said, you have to implement these. And if you don't, then you will be lacking in reasonable security. And I'm not 100% sure why they ended up picking SANS as opposed to, say, other things that we may be more familiar with, like ISO 27001 or NIST standards. But I want to say that having looked at the list of things that you have to do under SANS Top 20, they are similar to what you would have under a process-based security management framework. And they also, one of the other recommendations, now these are not musts. The state attorney general isn't coming out and saying you have to do all these things. So they're recommending that you do them. But I think they're also slightly saying that I've told you have to do these things, and there's a breach, and I find that what you're doing is egregious. I'm going to bring an enforcement action against you. You can read between the lines. And one of the things that they're doing here is implementing multi-factor authentication. And I think that's becoming more and more important as password cracking has just become a pastime for teenagers. It really has. And you can make your passwords as long as you want and as secure as you want. But if somebody has them in a table somewhere, and they will end up accessing your systems. And one thing that will save you is going to be multi-factor authentication, assuming that hasn't been breached if that does end up happening. And the other recommendation that the California Attorney General said was, hey, why don't you encrypt not just portable devices, but also desktops? Because what they saw was that they were seeing a lot of desktop devices being stolen from healthcare providers. And if that's not secure, then you have another breach on your hands. And they have been pushing in that area, and what they're seeing in their numbers from 2012 to 2015 is the number of encrypted devices in the healthcare sector is increasing, but they'd like to see more.
So what do you do to prepare? Because when you have limited resources and you have a ton of initiatives that your company's trying to undertake, how do you triage? What are the most important things to do so that you can prepare for something like this? And I think each of these settlements is very instructive because as you look at the settlements, the points that you see in them look fairly common. They look somewhat NIST-ish. They look like the ISO standard. They look like checklists that you would want to have in an information security system. But what's the hook? The hook is they want you to actually do it. So some things to consider in this mix is to begin by preparing, by doing intrusion testing. Find out where your weak points are. Use third parties to determine whether or not there are vulnerabilities that you have that you're not aware of. And there's probably how many vendors out there that offer services like that. But before an incident happens, create a data incident response plan. We've worked with companies to create that plan in advance, and it's important to have customer communications developed in advance, as well as people who you would identify on the team to determine whether the breach has occurred, what the corporate message would be. You need to anticipate regulator notifications if that would be required. And it's not just federal regulators. Now states all over the country are having particular notification requirements, whether it's by email of a breach, whether you notify the regulator, whether you have to do a publication or identify media. So it's not just enough to send something out to the customer. The other thing is the triggers are different depending on the kinds of information that were breached and the state where the customer lives. In some states there may be a duty to notify. In other states there may not be. So media is always a consideration. You need to know who the PR people would be in advance. Pick your team in advance before it happens. And then here's where your lawyers get involved by drafting internal privacy policies, which are internally facing policies for how people handle information, how they share it, how they store it, how they delete it, how they destroy it, and most importantly, vendor controls, right? And then external privacy notices that tell your customers or your employees or your business partners, put them on notice, how their information is going to be used. They need to match. Notices are two different documents, and they're not the same. One is a procedure for employees. The other is a notice to the people whose data is being collected. And then how do you keep it safe? You have to develop reasonable information security policies. Now here we are in 2016, and we've just done a presentation involving companies that really didn't have any to speak of, that were maybe siloed, where they had it for the parent company, but then they'd have subsidiaries or divisions that weren't even in the loop, that would have software developers that were not even trained in information security. And the other thing, too, to consider, you integrate these with your HR policy, so you don't just have to do privacy training. You can include that component with other employee training that you have. So you integrate them with your HR policies and then identify the data security team. You have physical security issues, access, hardware, badges, revocation, credentials, things like that. And then here's where I spend probably 60% of my time some months, is vendor management. So you have all of your procedures in place. Are you imposing those on your vendors so that the same standards that you expect of your own team are being imposed on the third party? And that really becomes a problem when your organization is mature, but you hire somebody to provide services because they're really cool, really fast, and they have something shiny. And you hire them, and it's a team of 6 people that are venture funded, that have 0 assets whatsoever, and they have insurance that really doesn't cover you because you're a third party and it only covers them, but they're getting a lot of credit card data or health data, or they're doing something, whether it's predictive analytics, whether it's data analytics, whether it's portfolio management. But you need to make sure that those companies are providing the same level of information security and protection, and that is a chase down a rabbit hole. It's an imprecise science, and I'd like to say that we've had a wonderful experience and everybody's doing it right. That might be somebody else's presentation, but it ain't ours. What we find is that it's an eternal journey. I feel like we're trudging through New Zealand in the Lord of the Rings trilogy, working our way to that destination of information security. At the end of the day, information security is a process, not a destination, right? So my point is simply this, is that don't just build your own fort and then leave an unattended door for the vendors to get the information. You need to make sure that they have the same standards. And if you can't actually make them financially liable, you at least need to have the controls in place so that you're auditing them, that you review their facilities, and that you have the controls in place. If you don't have the ability to do it yourself, at least put the controls in place. And that's what all these settlements indicate. Big promises of security, big promises of privacy, failure of controls.
With that, I think we'll move on to the international privacy section. I know some of this was spoken in the earlier legal presentation, so I'm not going to spend too much time on it. For those of you who are wondering, what is the safe harbor thing? Do I really care? No, you don't. If you didn't care about it before, there's no reason I don't think why you should care about it now, because something you didn't care about got ruled was invalid, and now something else is replacing it, and you will still not continue to care about it, because you don't have any international data. Right. But it was negotiated between the Department of Commerce and the European Commission for the transfer of personal data from the European Union to the United States. Because the Europeans, unlike us, look at privacy and say that's a fundamental right. And they treat it a lot more differently than we do. And they restrict it a lot more. And the enforcement under the FTC, the Safe Harbor, Department of Commerce Safe Harbor, was done by the FTC because, like I said, FTC is the de facto privacy regulator in the United States. And then a gentleman by the name of Schrems came up with a class action lawsuit, if you will, in Europe against Facebook and said, hey, you're transferring my data to the United States, and do you know, have you seen what Edward Snowden has said? They have access to everything, basically. And the Snowden revelations was the basis for this case that Schrems brought against the Irish Data Protection Commissioner relating to this Safe Harbor, Facebook audit. And the European Court of Justice looked at that and ruled it invalid from procedural perspective. And so for the past 6-7 months or so, the regulators have been trying to come up with a new way that will help us validate the transfers of personal data from Europe to the United States. And that is now called the US-EU Privacy Shield, the odd name. I don't know what we're shielding who, what from, but I don't think it's an appropriate name to begin with. The part that I think concerns all of us is the other issue that was probably talked about in the previous presentation, and it's relating to government's access to our data. How do we limit it? The Europeans would like to limit that to the extent that they can, especially when it relates to data that was collected in the European Union and then transferred to the United States. And there are several cases that I'm sure you're now aware of. The Apple encryption case that we're hoping we'd talk so much more detail about, but it kind of fizzled down because somebody said, hey, FBI, here's a YouTube video about how you can hack that, by the way. And the other case that you may or may not be familiar with is the Department of Justice's want to access data relating to an individual who resides in Ireland, and the email residing in Ireland can and should the FBI have access to that without going through the proper bureaucratic channels that sometimes you should when you're accessing data outside of your jurisdiction. Those kind of issues that where from a government access to personal data perspective that we're dealing with end up affecting multinational corporations that have employees abroad, that have customers abroad. When they choose to bring that data to the United States, those conversations that we're having are affecting these processes. So I think what's going to end up happening is here by the time June or July rolls around, we're going to have some sort of final framework that's going to tell us how we can go about transferring data from the European Union to the United States. It's not quite final yet. One improvement that they've done over the previous safe harbor is now there is a ombudsman in the Department of State, independent from the investigative and intelligence agencies in the United States under the Department of Justice, where if a European individual decides, hey, I don't know where my data is going, are you collecting this for national security purposes, they can go to the Department of State to resolve those issues, which is kind of unique. Having said that,
just so you know, if you think about this and you think, how does that affect me? How does EU data protection law affect me? Some of you may have pretty sophisticated plans for that. Do you have employees in the EU and you want to have their data here? Do you have shared email directories, phone systems? Do you have backup and disaster recovery and business continuity where your EU businesses back up their data here domestically? Any of that information passing back here or supplier information? or customer information. Anything that you want to move or collect from the EU here would be subject to that. And if you don't go through the approved compliance method, you've violated the law, and they can bring an enforcement action against your business there.
And the safe harbor wasn't the only method of transferring data to the United States, and the privacy shield isn't the only method either. There are other methods that you can use. They all have their advantages and disadvantages. Binding corporate rules can be expensive. Standard contractual clauses can be difficult to work with. Everybody's got to sign them. You need a board resolution from every foreign company to show to the local regulator, hey, this person is in fact authorized to sign that document. That's the other side of having privacy as a fundamental right, is you build a bureaucracy around it. A lot more than you may see of what we've described from the HHS and FTC perspective. And the other thing that's coming around is that the Europeans are now revamping their privacy regulation. It used to be called the EU Data Protection Directive that governed every personal data except for security, policing, etc. That was outside of it and still is going to be. It's not governed by the same type of law. They're calling the General Data Protection Regulation. A few things you need to know. Fines as high as 4% annual turnover. You're a $100 billion company, $4 billion maximum fine. I am sure that when that comes around, which it will, and most people are thinking that we'll see a huge fine from Europe regarding privacy to one of the tech giants in the next 2.5 years or so. But you get a $4 billion fine. There is no way you're going to say, here you go. So we're going to see some litigation. It's going to happen in Europe. It's going to go all the way up to their Supreme Court, which is the European Court of Justice. And then we'll see if they'll stick. And if they do, then you're going to continue to see major fines, and you're going to see the general data protection a lot more. 72-hour data breach, that is a new standard. If you have European data, that's how much time you have. In the United States, it may be 30 days, 90 days. Expedition is the standard. But if you're looking at days, 3 days, that's a tough standard to live up to. One of the other things I want to plug in here is I know we're the security community. The International Association of Privacy Professionals as another organization, and we have local knowledge nets. And there's going to be a presentation about international data transfers, both relating to the Safe Harbor Privacy Shield, General Data Protection Regulation, and other issues upcoming in May. If you're interested, feel free to stop by, let me know, and then I'll see if I can get you an invitation. But I know most of the other people from IAPP here, I'm sure they'll be there, right? Good. All right. So what should you do? I know Dino and I briefly talked about it. Implementing security and privacy by design. That is key. We've been talking about it for the past several years, I want to say, ever since we've been doing these ISSA and information security summits. It is now a reality simply because the regulators want that. When you're rolling out any kind of product, you must think about security and privacy beforehand, as opposed to trying to bake it in later, because that's going to result in an enforcement action. You have to understand what data that you have, where you put it, where you transfer it, and how you use it. You need to conduct the risk assessments. You have to address those risk assessments, because we talked about Dwolla. They did that penetration test, and they didn't act on those results, and they should have. Prepare for a data breach, because sadly that will happen sooner or later, and you need to make sure that everybody knows what to do. And one of the worst things you can do in a data breach is fumble. Tell people, oh, nothing got breached. Oh, more things got breached. Oh, not that many things got breached. Just a little bit of things got breached. And next thing you know, people get fired. You don't want to be that guy who loses his job. And then cyber liability insurance, because that's how you take care of risks that you can't entirely control. I think that's become a reality too, is to try to remove some of the financial liability that you have with respect to breaches using insurance. And then finally, just don't do it once and forget about it. You got to make sure you do it over and over and over again. And I want to say we will end, as usually we do, with a Dilbert cartoon. I know us attorneys like to be, oh no, it's the end of the world. A visionary leader will not be born if this agreement is signed. Well, we hope we weren't that alarmist today. Anyhow, we're here for questions, but I think we're over time. Feel free to ask questions afterwards.
Yeah, we appreciate your time. Thank you very much for taking time out of your schedule and coming today.